The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, October 29th, 2024. Yeah. Are you ready for me to go on? Or are we okay? From the beginning? Sure. Okay. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, October 29th, 2024. My name is Deborah Dryden, and I'm chair of the board. Would the board members please go around and state their name for the record? Mr.
Okay.
Hamilton Court.
Thank you. Also present are Solomon Fortune, our zoning administrator, John Kinley, our senior project manager, Crystal Monsegur, our planner, Kamisha Lampley, clerk to the board, Therese Hagler Gray, senior assistant city attorney and advisor to the planning staff, Nicole Hewitt, assistant city attorney, advisor to the board, and Jill Sanchez Meyer, senior assistant city attorney, advisor to the board. Christy Clark is our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards and ordinance and based on the facts presented. If you'll be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. Certain topics this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they are based on their opinion, While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may be present, may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial business or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing that may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by any affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case and a sworn witness provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or appeal. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from the board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D 405D. Okay, we now open the evidentiary hearing for case number 2024-00044. The property is located at 2017 Whittington Street. Before we begin, does any board member have a conflict of interest or potential conflict or any ex parte communication they need to disclose? Okay. At this time, I'll administer the oath for all individuals who intend to provide witness testimony. Do you solemnly swear or affirm that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you, Mr. Kinley. Okay.
It's by UDO Investments LLC, represented by Zachary House of Seedwater Engineering for a property located at 2017 Whittington Street, and the property is owned by the applicant UDO Investments LLC. Variance is to request to reduce the required 3-foot Class A landscape yard abutting into B zoning per table 20-3 and 20-2 of the UDO. The 10 to 10 foot in width with 6 trees and 20 shrubs, and the reduction in the width would represent a 30-foot reduction in that width and a modification to the required plantings. This is the vicinity map of the site. We're up Statesville Avenue, north of Atondo. There's some property there along Statesville that's zoned industrial, or in this case, manufacturing logistics. It was prior to the UDO, it was zoned industrial. The parcel existed prior to 1985, and the building was constructed in 1962. And you can see the building on the site with the red star. And then the property to the west is the property that's zoned into B zoning. Here's an aerial view of the site. You can again see the existing building with the red star, and then the abutting property to the west is zoned into B with 2 existing single-family homes on. They're really small single-family homes on parcel. Here's the bird's eye view. You can see those existing single-family residential structures to the west, or to the right in this case, and the existing building on the left-hand side of the screen there. And a street view image. This is looking at the existing building that's the subject of the variance. And you can see that there's currently no landscaping or anything between the subject site and the existing buildings to the right of the screen. Variance request to reduce the required 40-foot Class A landscape yard abutting into B zoning per table 20-3 and 20-2. Those tables are in the findings of fact documents that Kamisha passed out a minute ago. And you can see that M&L zoning requires a Class A landscape yard when abutting any other zoning district except CR, ML1, ML2, I1CD, and I2CD zoning districts. And then the width of Class A yard, landscape yard is based on the acreage. Anything that's 3 acres or less requires a 40-foot wide landscape yard. So that's the main part of the variance request. And they are proposing a modification to the required shrubs and landscaping, which I'll cover in a minute.
Is
Here's
it, is that a single family dwelling right there? Is it a house? What is it, the house that's on the land right now?
So originally it was constructed according to tax records as a single family home, but it's the tax use code is industrial. So I'm not sure if it'd been converted to industrial use at some point in the past or not. It's unclear what the history of it has been. But it's had some additions and modifications over the years that we could see in the aerial imagery. But it is zoned for industrial use.
But the two houses to the right are not zoned industrial.
No, they're zoned into B, and they're, I think, single family homes, but they're both on the same parcel. So I believe they're probably rentals, but I don't know for certain.
Thank you.
Is there a change of use?
So yeah, what's triggering the request is they are basically, the property is currently vacant, and they would be proposing to establish a, I think it's an employment place where you can get like employment office, I guess is what you call it. So it's not really even an industrial use that they're proposing. It's just a use that's allowed in that industrial zoning or the manufacturing logistics zoning. But because of that improvements that they would be making to the site with the parking and renovation of the inside of the building and other improvements, would be required by the ordinance to install this landscape yard because they're abutting that neighborhood to zoning. And as you can see, because of the location of the existing building, there's not really room for the landscape yard. So the dash line running down kind of the middle of the site is the 40-foot required landscape yard. They're requesting to reduce that to 10 feet. And that's just to give them some space between the building and the landscape yard for access and maintenance around the building. There's really only 14.9 feet between the property line and the building. So they're trying to maintain a little bit of access for maintenance of the building, but then also install landscaping and vegetation within the space that they would have left, which is about 10 feet.
So the houses, though, that were the duplex, they're on the left of this picture, right?
So they'd be right here.
Right.
They're not shown, but they're right here.
Yeah, I can see how close the property line is to the driveway of those other two houses. Okay.
So the final width of the proposed buffer would be 10 feet, and then they are proposing to provide 20 shrubs, and it's about 99 linear feet, or roughly 100 feet from the front property line to the rear. So we're talking about 100 feet. The ordinance requirement would require basically 55 total shrubs. They're proposing to provide 20, and then they are required ordinance to provide 4 trees, and they're proposing to provide 6 trees instead. So they're providing less shrubs, more trees, and then that'd be within the 10-foot reduction in width that they have to work with. These are the standards for granting the variance. All those need to be shown to be met in order for the variance to be granted. And I will note that the applicant has agreed to a condition that the variance be applicable or applies only to the reuse of the existing building. So they agreed to that condition. So in that case, if this building was ever demolished and they were to build a new building on site, then you would need to comply with the ordinance requirements or come back through for another variance or whatever.
Okay.
So staff looked at this, and we believe that unnecessary hardship would result from the strict application of the regulations due to the size of the lot and the location of the existing building on the lot. The lot is about 100 by 100, and a 40-foot landscape yard reduces that buildable area by 40%, and the existing building would have to be demolished to accommodate the landscape yard. Hardship does result from conditions that are peculiar to the property, The lot existed prior to the UDO's requirements for landscape yards, and the building was constructed in 1962 prior to the zoning requirements for buffers and landscape yards. And the existing building is to remain and is located 14 feet from the western property line abutting the N2B zoning. Hardship did not result from actions that were taken by the applicant or the property owner. The applicant or the property owner did not create the lot, and they did not construct the building in the current location. Proposed use is permitted in the ML1 zoning district. The requested variance is consistent with the spirit, purpose, and intent of the regulations that shuts that public safety is secured and substantial justice is achieved. The request would allow the reuse of the existing building on the site, and the applicant will install a minimum of 6 trees and 20 shrubs along the western property line. And there's currently not any landscape screening between the building and those abutting into the zone courses. So we do believe that it's improving the conditions that are currently there. And there's the sign on the property and the current appearance of the property on as it stands within the last few weeks. And I'll take any questions.
Where, I'm just looking in the finding of facts, where does, I don't see the exception that the property owners have said they can only do this existing building, and if the building's ever torn down. I don't see that anywhere. Do you know where it is?
Look on page 2, where it says staff supports the requested variance to the landscape yard with the following condition: the variance applies, and that should say to the reuse of the existing building.
The variance applies to
the reuse of the existing building.
Chairperson Dryden,
yes, ma'am.
our recommendation would be that that is made part of the findings of fact as an additional finding under 19, just reflecting what the testimony has been. Our recommendation would be that it read, the applicant has agreed to the following condition, and then list the condition as it has been stated.
Thank you. That's what I didn't see anything in the finding of facts that stated that, and it's nice that you say it, but I'd like it in writing if we're going to approve this variance. Okay, so should we add that now, or should we wait till we do the finding of facts?
You're welcome to add a draft to it, but it would be approved once you approve the findings of fact.
Okay. All right, so we'll table that till we do the finding of facts, but we are going to add a number 19 that says the applicant has agreed to only, I don't know how to say that, but it's only.
The variance applies to reuse of
The variance applies only to the reuse. Okay, we'll come back to that when we do the finding of facts. Any other questions for John?
So they're basically doing a commercial use of the property.
Correct.
What's the buffer requirement between a property that's zoned commercial and a neighborhood?
It would be a Class B landscape yard, which requires a 25-foot width.
Okay.
So if they left it alone, they would, right now, they wouldn't have, they're asking for this variance because they want to do some upgrades to the building. Is that my understanding?
Because the building is currently vacant and they would need to make some interior renovations and then also construct a parking lot because there's not a parking lot on the site right now either. That is what's triggering the requirements to install a landscape yard.
Well, I'm sure if I was a neighbor, I would appreciate shrubs. Something between that. Okay. Any other questions for John? Is there anybody here in opposition to this, John?
No.
All right, thank you. All right, discussion, ladies and gentlemen. All right, do I hear a motion to approve or disapprove this variance?
So a motion to approve the variance.
Okay, Ms. Sun has made a motion to approve the variance. Do I hear a second?
Court second?
Really quickly, before you vote, it would be recommended that you state that your motion include the condition as well. So it could just be restated, approve the variance with the condition.
Okay. Ms. Sun, would you repeat that, please, that you approve the variance with condition?
Yes, I approve the variance.
And Mr. Court, you second that?
I do second that.
All right. Mr. Williamson? Approve with?
Approved.
Approve. Mr. Shea?
Shea approved.
Mr. Court?
Court approved.
Ms. Sun?
Sun, yes.
And Dryden approves with the condition. All right, so the variance is approved. So now let's look at the finding of facts because we have to add number 19. And according to Ms. Hewitt's suggestion, say the applicant
Variance is approved.
and variance. You want to
Applicant
read?
has agreed to the condition that the variance applies to the reuse of the existing building.
Agreed. Variance.
Only,
The variance,
If you want to add, only, that's. fine.
yes, the variance,
we'll just take that sentence at the very top of the page and try to recraft that. So
yeah,
that-
the variance, the applicant approves the variance will only apply to the reuse of the existing building.
And try to match it up with the verbiage that's on the sheet.
Yeah.
The-
You want to take that out? You want to take that, make that number 19 by
Yeah,
itself?
yeah, we're gonna do 19 by itself.
Well, Hamilton's talking about.
Oh,
up top,
okay.
It says the variance only applies to the existing building. So it's.
Right, and we just make slight modifications to that. So at the very beginning, we say the applicant has agreed that,
As agreed.
And then we take the,
Variance.
as written.
The variance only applies to the reuse of the existing building.
There you go.
Okay, does everybody have that clear?
And
Do I have it clear? Yes.
And again, that should be included in the findings of fact. So
Right, that's
even
gonna
if,
be the number 19. So new number 19 reads, the applicant has agreed that the variance only applies to the reuse of the existing building.
Got it.
Okay. Do I hear a motion to approve the finding of facts and conditions of law as amended?
Hamilton Court moves to approve the findings in fact and conditions of law as amended.
Thank you. Do I hear a second?
Shea second.
3 seconds. Okay, Mr. Williamson? Okay, Ms. Sun,
Sun, yes.
Mr. Court,
Court, yes.
Dryden, yes.
That was Shea.
Shay?
Shea said yes too.
Shay.
Thanks for including her.
It's been a long morning. Okay, all right, the finding of facts and conditions of law are approved as amended. Thank you very much. Okay,
The only other items we have on the agenda would be approval of the September minutes and then the November and December meeting dates.
all right. Do I have a motion to approve the minutes from the September meeting?
Court moved to approve.
Thank you, Mr. Court. Do I hear a second?
Sun, second.
Ms. Sun seconds. Mr. Williamson?
Williamson, yes.
Mr. Shea?
Shea, yes.
Mr. Court?
Court, yes.
Ms. Sun?
Sun, yes.
Dryden, yes. So the minutes are approved. All right, now we need to talk about the dates. We discussed this at our last meeting. Thank you, gentlemen, for coming. About our November and December meetings. And Mr. Kinley, you'll have to refresh my memory because I don't even remember what we talked about. I mean, I know
So-
we talked about it. but-
Yeah, you guys discussed the moving the November meeting to the 19th and the December meeting to the 17th.
Right, those are the, all right. So is everybody looking at your calendars? Does that work for everybody? And Ms. Hewitt? You
That
want
works.
Okay, it works out. Okay. So there is a motion to move the November meeting to the 19th. And the December meeting to the 17th.
Do I need to make that motion?
Yes.
Okay, I will make that motion.
All right. The motion has been made that we move the November meeting to the 19th of November, Tuesday, and the December meeting to the 17th of December. Do I hear a second?
Williamson, second.
Williamson, second. Okay, Mr. Court,
Court, yes.
Ms. Sun,
Sun, yes.
Mr. Shea,
Yes.
Mr. Williamson,
Yes.
and Dryden, yes. So we have officially moved those meeting dates.
Perfect.
Thank you very much.
We don't need any findings of fact.
Yes, sir.
Trying to get case on these, but it looks like.
Okay.
And December, so if you guys let the commission know, if anybody's not gonna be there for some reason,
It'll be a full day.
Yeah.
it'll be a full day.
Okay.
In December, I will not be here. I'll be traveling in Asia.
It's kind of like my budget, everything gets pushed down to December.
Yeah, yeah. Well, I mean, I appreciate you moving the dates because, I mean, it's just, the 31st would be hard, right, right after Christmas and New Year's. Okay. All right. So Ms. Sun will not be here, so that gives you
In December only.
in December. So that'll give you, Ms. Lampley, some time to get us some alternates in here. All right. All right, that concludes the meeting. Thank you very much.
Thank you.